Good evening, everyone. Thank you for joining us. Tonight, we have Kayla Williams, CLS staff attorney over our landlord tenant program, and she can take it over from here.
Hi, everyone. My name is Kayla Williams, staff attorney with Community Legal Services of Prince George's County, and I manage the tenant representation program. So you can usually find me running around Hyattsville District Court. Today, I will be presenting on landlord tenant cases and moratoriums and other matters that you should be aware of in the midst of COVID-19 and the pandemic. So I'm going to share my screen, and give me 1 second.
And just to add, if you're watching afterwards, you can contact our office if you have any questions regarding landlord tenant matters, and we'll be happy to assist.
All righty, can you all see? All righty, can you see it?
It's live. You're good.
Alrighty, so this presentation is entitled Evictions During COVID-19. Again, I am Kayla Williams, staff attorney with Community Legal Services. So the district court is currently in phase 5 of its reopening plan. What that means, it is currently on its way to being fully operational. So they are hearing all types of landlord tenant cases. So if you are summoned to appear, you should absolutely appear. We will be discussing tonight rent escrow cases, tenant holding over actions, breach of lease actions, wrongful detainer cases, failure to pay rent cases, as well as warrants of restitution. We'll explain more what these all are soon. Okay, so first I would like to begin with the current eviction moratoriums and local protections that are in place as of today. So if you are summoned to appear, if you've fallen behind on your rent, there are certain things that you should be aware of. There are certain defenses that you may be able to raise. 3 important ones that we'll talk about tonight include the CDC eviction moratorium, Governor Hogan's order temporarily preventing certain evictions due to substantial loss of income, as well as Prince George's County Bill CB 16/2020. So first we'll start with the CDC eviction moratorium. What this entails is essentially if you are summoned to appear for a non-payment of rent case, if you sign this declaration form indicating that all of the terms agree to or apply to you, that you've suffered a loss of income, that you've attempted to pay as much rent as you can sign this form, give this form to your landlord, and if your landlord files a non-payment of rent case, the court cannot order an eviction through December 31st. Make sure though, this moratorium is not automatic. So it requires you to give the form to your landlord. And if you are summoned to appear in court, you still should always make sure that you appear. That way you can bring it to the court's attention that you have given the form to your landlord. Keep in mind, the CDC moratorium, it essentially is delaying an eviction. So it doesn't stop the rent from being due. And it's only delaying the eviction as of right now through December 31st. What that means is come January, the landlord may attempt to move for an eviction depending on if there were any previous cases that were filed. Also keep in mind that the CDC eviction moratorium arguably only applies to non-payment of rent cases. What that means is a landlord may try to evict you on a different matter. For example, if they allege that you've breached the lease or you've done some type of unlawful activity on the property. Keep that in mind. These are essentially what are required for the tenant to show in order to be eligible for the CDC eviction moratorium protection. These are all laid out on the declaration form, which I'll provide a link on the next slide, but I just wanted to kind of give you a summary of them. Essentially, you are signing this form and stating that you have tried your best to secure government assistance or some type of rent assistance to pay your landlord. You're stating that you make no more than $99,000 a year, or if you're joint filing or if you're filing your taxes with your spouse, that you haven't together made more than $198,000. You You must show, or you must swear when you're signing this form, that you are unable to pay your rent due to extraordinary medical costs or things such as loss of income, or you were sick and you lost your job, things like that. Any type of substantial loss of income. You must show that you are using your best efforts to at least make some type of partial payments. So if you haven't paid your rent since last January, it may be a little difficult for a court to show that this moratorium applies to you. So you want to try to make it a little easier for the court to give you this relief and try to pay as much as you can, even if that means partial payments or a little bit each month. Additionally, by signing this form, you're indicating that an eviction would likely render you homeless, and therefore you need this type of support. Okay, so here is a link to the declaration form. Again, if you are summoned to appear for a non-payment of rent case, you should absolutely appear at your hearing. But you can also make sure that you give your landlord a copy of the CDC form. That way you can protect yourself. And again, that means that no eviction can be ordered for a non-payment of rent case through December 31st. Okay, so we've talked about the CDC moratorium. Now we will move on to Governor Hogan's order, which temporarily prohibits evictions. So Governor Hogan's order says that as long as there's a state of emergency in place, that the court is prohibited from ordering an eviction if a tenant can show through verifiable means or through documentation that their failure to pay rent is a result of a substantial loss of income. What that means is if your landlord files a non-payment of rent case against you, you can go to court and say, Your Honor, I have lost my job. I lost my job in March when everything closed down, and I have either not been able to find employment or I'm still trying to catch up. Or if your hours have been reduced, or if you were sick or taking care of a loved one, for whatever reason, for as long as there's a state of emergency declared by Governor Hogan, if you can show a substantial loss of income, this eviction moratorium, Governor Hogan's order, will apply to you. Keep in mind that this requires documentation or verifiable means. So if you are summoned to appear and if you have a letter from your employer indicating that you were laid off or your hours were reduced, etc., you should bring those to court. That way, an attorney or you can help you raise this defense. Keep in mind that this order, again, similar to the CDC moratorium, only applies to non-payment of rent cases or failure to pay rent cases and breach of lease cases. Okay, next we will discuss the Prince George's County Council Bill, CB 16-2020. This was passed this summer, and it essentially says that a landlord shall not increase rent for a tenant who can show they've experienced a substantial loss of income if that rent increase would take effect during the state of emergency and within 90 days after. So this rent increase portion applies to tenants who are able to show their landlord that they've suffered a substantial loss of income. So it appears that it's not a blanket protection. It doesn't apply to everyone. It requires the tenant to show their landlord they've experienced income loss. But then you have the portion of this bill that states that a landlord shall not impose late fees or penalties for any tenant if the late fees and penalties would take effect during the state of emergency and within 90 days or after. So regardless of whether or not you suffered a substantial loss of income, a landlord cannot charge you late fees during this time as long as there's a state of emergency and within 90 days after that emergency is lifted. Okay, so those were the three important moratoriums that you should be aware of. You have the CDC moratorium, Governor Hogan's moratorium, and you have the Prince George's County bill, which prohibits late fees and certain rent increases. Keep in mind that during this time and always, non-judicial evictions are illegal. What that means is regardless of whether you owe rent, regardless of whether your lease has expired, your landlord cannot evict you without going through the court. This is codified in a statute, which specifically says that if you are illegally evicted, meaning if your landlord attempts to evict you without a court order, the tenant may be able to sue. We'll go more into detail about how evictions take place in the court process, but I just wanted to detail this. And I've created a little, I guess, display. They're kind of just characterizing the process that a landlord must take before they can actually try to remove you from the property. So in order to remove you from the property or attempt to, your landlord is required to file a complaint with the court. This could be a failure to pay rent complaint, a breach of lease complaint, some type of complaint seeking possession of the property. Possession is equivalent to an eviction. Essentially, your landlord is asking for the property back. After your landlord files the complaint, the court will set in a hearing and the tenant will be summoned to appear. At that hearing, in order to evict a tenant, a landlord must receive what's called a judgment for possession. That means the court must rule in favor of the landlord, essentially meaning that the tenant would lose their case. So after the landlord obtains a judgment for possession, that's not enough. The landlord then must request a warrant of restitution. The warrant of restitution is what allows the sheriff to actually oversee the eviction process. So a landlord must first file the complaint. They must obtain a judgment for possession. They must then request a warrant of restitution. Once they request that warrant of restitution, they then have to contact the sheriff's office to execute that warrant, or in other words, to oversee the eviction. They must follow this process. Okay. Some examples of an illegal eviction are, they may not be as clear as you think. So, of course, your landlord can't change your locks or turn off your electricity. They can't remove your belongings without first getting a court order and going through the court. They can't turn off your water. Even turning off your Wi-Fi arguably can be seen as a constructive eviction. Keep in mind again that these are forms of, or could be seen as forms of a non-judicial eviction. So you want to always make sure that you're going through the court, you're not turning off someone's services without having that court order. Okay, so in the unfortunate event that you do find yourself evicted, here are some resources, or evicted unlawfully, here are some resources. You can file a complaint with the Maryland Attorney General's office. They essentially have a mediation department under the Consumer Protection Division. You can also sue for damages. So if you've been illegally evicted and you've had to incur hotel costs or medical bills, or if your property was stolen or damaged, you may be able to file a civil case to be reimbursed. So just as a summary, in order to evict you, your landlord must file a complaint. They must obtain a judgment. They must then obtain a warrant of restitution, which can only be executed by the sheriff's office. Okay, so now we've discussed eviction moratoriums. We've discussed the prohibition of non-judicial evictions. Now we're going to move into the different types of landlord-tenant cases that exist. So if you are summoned to appear in court, you could be summoned to appear on any of these cases. We will talk about failure to pay rent cases, which make up the bulk of our work. That is where a landlord is alleging that a tenant has failed to pay rent, and as a result, they want possession of the property. We'll discuss tenant holding over actions. That's where a landlord alleges that the tenant's lease has expired, that the landlord has given the tenant notice to vacate, and that the tenant still is in the property. We'll discuss wrongful detainer actions. That's when a homeowner alleges that the occupant has no legal right to be in possession of the property. We'll discuss rent escrow actions. That's when a tenant is alleging that there are significant defects in the property to which they brought to the landlord's attention, but which the landlord refuses to fix. And then next we will discuss breach of lease cases. And that's when a landlord is alleging that a tenant has violated a term of the lease and that that violation warrants an eviction. So failure to pay rent cases, again, these make up the bulk of our work. That is when a landlord is seeking possession of the property and the landlord is alleging that the tenant has failed to pay rent. As a result, they want the property back. A failure to pay rent case can be filed by the landlord, it can be filed by the landlord's agent, or it can be filed by an attorney. Complaints may include base rent. They may include late fees. Obviously, late fees can't be applied now in light of COVID and the state of emergency, but typically they can be applied. Keep in mind, in Prince George's County, late fees cannot be more than 5% of your rent. And sometimes we'll even see additional rent. So that means things like utilities or trash fees or pet fees, things like that. Sometimes the landlord will try to include those as additional rent. What I would say is just always review your lease carefully, because there may be an argument to be made as to whether or not that can actually be charged as rent. Keep in mind that the bulk of the cases, or all of the cases that I'm discussing today, involve possession of the property. So in other words, we're talking about cases in which the landlord is seeking an eviction. We're not talking about money judgments. So when I say judgment for possession, that means an eviction. Versus a money judgment, that's when someone goes to civil court and is looking to garnish your wages or file a civil suit, take you to collections, etc. So this is, I think they updated their failure to pay rent complaint, but this is a copy of what it typically looks like. I have kind of marked the boxes in which the landlord is required to fill out. Oftentimes, if these areas aren't filled out correctly, those could give rise to certain defenses that you can raise in court. So your landlord must provide their name, their address. They must indicate all tenants that are on the lease. They must indicate where the tenant resides. If there's an apartment number, that apartment number has to be included. The landlord must indicate whether or not they have a license to rent the property. We'll discuss more what that is in a moment. The landlord also must indicate whether or not their property is affected by lead paint. They must indicate how much they're asking for and which months they're asking for. A tenant is entitled to notice, so you are entitled to receive notice in advance of your court hearing. That way you can gather any proof or receipts that you have. Additionally, they have to indicate the total amount that they're asking for. And this line 7 means that if your landlord is requesting rent that's due after filing, the landlord must indicate that, and they must check that box. For example, if this complaint is filed in August, but it isn't heard until September, in order to get both August and September rent, the landlord must have checked that box unless they've indicated somewhere else in the complaint. Okay, so in Prince George's County and in most counties, a landlord is required to obtain a rental license, meaning that they have to contact the county. The county has to do an inspection of the property. The landlord has to pay a fee. And the reason for this is the county wants to make sure that the property is safe and is up to code and is safe for the landlord to rent out. The only exceptions in Prince George's County to a landlord obtaining a rental license is if the tenant is the landlord's parent, child, sibling, grandchild, or in-law, if the landlord is an active member of the U.S. Armed Forces and maintains the property as their permanent residence, or if the landlord has been relocated for employment or education and maintains the property as their permanent residence. So Prince George's County, the court, they do a really good job of making sure that a landlord has a valid license whenever there's a failure to pay rent case that's on the docket. But if you ever had questions, of course, you can always ask the landlord to see a copy of their rental license. And I believe you can also contact the county to request a copy of that license. Before the county issues a permanent license, they'll issue a temporary license, which may or may not be sufficient for the court to proceed. Essentially, a temporary license just means that the landlord pays a fee, but an inspection hasn't actually been done. So ideally, the landlord will have a permanent license in which they've paid a fee and the inspection of the property has been done. So in addition to a rental license, there's also the requirement that if the landlord's property was built before 1978, that the landlord must certify that the property has not been affected by lead paint. And to do this, they must register the property with the Maryland Department of Environment and request an inspection. This is just to keep everyone safe and to make sure that there is no lead paint. Okay, and keep in mind that a lead paint inspection is required for each change in tenancy. So here are some common defenses to a failure to pay rent complaint. If you raise any of the moratoriums, those will hopefully delay an eviction. If the complaint is incomplete or if it's not signed, if the amount of rent requested is incorrect, or if the complaint does not indicate what months or weeks the rent is owed, the tenant's property address isn't listed, or if tenants who reside in the property or who are on the lease were not served with notice of the rent filing, the landlord must have a ledger. So keep in mind that even though these complaints can be filed by a landlord or their agent or an attorney, they still should have an individual present that can verify the payments. So it is the landlord's burden to prove what amount of rent is owed. But this, as the tenant, you should also bring receipts and any proof that you have. And again, late fee can't be more than 5% of the monthly rent. And there's many other defenses that may also be applicable, but these are some of the most frequent seen that we see. Okay, so in regards to the failure to pay rent context, even if the court determines that a tenant does owe rent, and even if they award a judgment for possession to the landlord, a tenant still has what's called the right to redeem the property, meaning that even if a judgment is entered, the tenant can pay the amount of that judgment anytime before an eviction takes place to stay in the property. That means even if the sheriff comes knocking at your door and says, hey, there's a judgment entered on this date, you can still tender payment at that moment to avoid an eviction. The only exception to this is if the tenant has 3 or more prior judgments within the past 12 months, and the landlord has requested for the right to redeem to be foreclosed or to be taken away from the tenant. That's the only exception where even if you pay your money, the landlord can still evict you. All right, and then just keep in mind that if the landlord's attorney does wish to take away your right to pay to stay, that would be indicated on the complaint. So you would have notice of that and you could raise any objection that you have. Okay, so we've talked about eviction moratoriums, we've talked about failure to pay rent cases. Now we will discuss rent escrow cases. Rent escrow pretty much goes hand in hand with failure to pay rent. Rent escrow can be filed at any time by the tenant, or it can be used as a defense against a failure to pay rent case. So a rent escrow case essentially is the tenant's case. So it provides the tenants with the mechanism to encourage the repair of serious and dangerous defects, which pose a substantial and serious threat of danger to the life, health, and safety of occupants. Essentially, if you have put your landlord on notice that there are defects in your property that pose a threat to your health or safety, and your landlord refuses to fix these issues, you can file what's called you can file what's called a rent escrow case. Or again, you can raise it as a defense to a failure to pay rent case. This is not available to tenants who have 3 or more prior judgments for possession within the last 12 months, unfortunately. However, so keep in mind that the rent escrow, it applies to serious defects. So some of the serious defects that the statute lists include a fire hazard, lack of heat, light, electricity, or hot or cold running water, lack of adequate sewage disposal facilities. So like if your toilet is backed up, or if like sewage is coming out of your tub, things like that. Those are pretty serious. Or if there's an infestation of rodents in your unit, or if there are certain structural defects which present a threat to your health or safety. These all may be grounds for opening a rent escrow case. This list is not exhaustive, meaning there may be other issues that also give rise to a rent escrow case. Keep in mind that a prerequisite to filing a rent escrow case is the tenant must put their landlord on notice of the defects and give them an opportunity to repair. So say, for example, your ceiling is caving in. You must have first told your landlord that this issue exists, and you must give them the opportunity to fix your ceiling. Your landlord is going to, or the statute provides that the landlord should be giving a reasonable opportunity to repair whatever issue exists. And reasonable is going to depend on the circumstances. So obviously, if your ceiling is caving in, that's a little bit more of an emergency than maybe you saw 1 or 2 ants in your property. So keep in mind, though, that there's a presumption that anything over 30 days is going to be considered unreasonable. So if you told your landlord your ceiling is caving in and it's been 4 months and they still have not been to the property, arguably that's unreasonable. And there shouldn't be a problem with opening the rent escrow case, as long as you put your landlord on notice. Okay, and again, your landlord must have refused to fix the issues. So if the issues have already been fixed, but you're wanting to recover money based on the damages, rent escrow wouldn't be the best option. You'd probably be better off filing a civil case unless the issues still exist. Some of the defenses that a landlord may raise are the landlord wasn't given notice of the issues, because arguably, how can they fix something that they weren't aware of? Or they can argue that the tenant or their guest caused the defects, or the landlord can argue that they were denied access to repair. So keep in mind that if you do put your landlord on notice of certain issues that exist in your property, you want to give them the opportunity to repair. Of course, they have to give you reasonable notice before entering your property, but you don't want to just say, I'm not going to let you in because I don't like you. You don't want to do that. Okay, so once the rent escrow case is open, the tenant will be required to pay their rent to the court. Keep in mind that failure to pay the rent that is owed could be grounds for dismissal of the rent. So say, for example, you told your landlord that your ceiling was caved in August and it's now October and you have your rent escrow case today. The court would order you to pay August, September, and October's rent to the court. And if you fail to do so, that could be grounds for dismissal of your rent escrow. So after the rent escrow case is opened, the court will order you to call the inspector and set up an inspection. This inspector will create a detailed report of the issues that exist, and they will then submit that report to the court. That way, on your next hearing, the judge will have a copy of the inspection report, and you'll be able to give an update to the court as to whether or not the issues have been fixed or not, and whether or not you want to keep the case open or whether you want to close it. Keep in mind that the tenant can keep the case open for as long as the issues exist or until they get tired of having to come to court and pay their rent to the court. But hopefully, the goal is to get the issues fixed. So in a rent escrow case, the tenant can request certain remedies. If the repairs are made, the landlord could request that the money that's been paid into the rent escrow be returned to the landlord. Or if the repairs have not been made, the tenant can ask for a portion of the rent that's been paid to the rent escrow. Or if it's been over 6 months in which the rent escrow case has been open, the tenant can request that all of the money be returned to the tenant. The court usually, from what I've seen, doesn't award 100% of the rent escrow funds to either party if there's been some effort by the landlord to fix the issues. But the court will take into consideration how long these issues have existed when you put your landlord on notice, how severe the issues are, etc. A tenant can also ask for their rent to be reduced moving forward as a result of the issues and how long they've incurred. And lastly, the court may order that some or all of the money paid into the rent escrow be returned to the landlord or to the tenant in order to make the necessary repairs. Okay, so next we will talk about tenant holding over cases. This is essentially where a landlord is alleging that there was a valid lease, whether written or oral, that the lease term has expired or that there was a month-to-month tenancy, that the landlord has given the tenant at least 1 month's written notice to vacate. I would say look at your lease very closely because sometimes the notice provisions vary. It could be 2 months notice is required, or it could be 1, but just pay attention to that. So essentially your landlord is saying there's a valid lease, that the lease has expired, that they've given you notice, and that the tenant still resides in the property. If the landlord alleges these things, and after that notice period, the landlord can then file what's called a tenant holding over case. Unfortunately, the way that the moratoriums are written, it's difficult to show that they apply to tenant holding over cases you can make the argument, but unfortunately, these cases are difficult because we're not finding that essentially some of the moratoriums don't apply. So I would just say keep an eye on when your lease expires, see if you want to renew your lease or be thinking about backup plans just in case. Okay, next we'll talk about wrongful detainer cases. A wrongful detainer case is when a homeowner is alleging that the person who's occupying the property has no legal right to be there, meaning that they're not a tenant, that they're not paying rent, that they don't own the property, etc. The homeowner must show that they do own the property, meaning they might have to provide a deed or something showing that they have the right to bring the case. One of the issues that we see sometimes in wrongful detainer cases are if there was, say an oral lease, and the landlord or the homeowner is accepting rent from the tenant. That is still a tenancy if the landlord is accepting payment in order for the tenant to reside in the property. Or in certain domestic violence cases where the court has given the tenant or the occupant possession of the property or the right to stay there, essentially by court order, say by a protective order, that could also be a defense against a wrongful detainer action because you do have the legal right to be there. Okay, and next we will talk about breach of lease cases. And this is when your landlord is alleging that there was a valid lease agreement between the landlord and the tenant, that the tenant breached a term of the lease, that the landlord has given the tenant at least 30 days written notice of the lease violation, or 14 days if they're alleging that the tenant's behavior poses an immediate and imminent threat of harm, that written notice must expire before filing the breach of lease action, and the landlord must prove that the breach was substantial and that the breach warrants an eviction. So one of the common defenses that a tenant may have in these cases is maybe there was a breach. Maybe there was a dog that wasn't on the leash or, something along those lines. However, is it substantial and does it warrant an eviction? Maybe not. Could be a breach, but it has to be substantial and warrant an eviction. Okay, so that concludes my presentation for tonight. These are some helpful resources. If you have any questions or if you have an upcoming hearing that you might need assistance with, feel free to call us at 240-391-6370, or you can visit our website at www.clspgc.org. The People's Law Library, that's a really good resource if you just want to look up your rights. They do a really good job of breaking down the statutes into simple terms. Also, the Maryland Court Self-Help Center is a great resource as well. They provide general brief legal advice. They don't really provide representation though. And lastly, the Maryland Court's website has a lot of forms and helpful information that you might also need. Okay, any questions? And I will take it back to the home screen. Okay. If you have any questions, make sure that you leave us a comment.
Okay, if there's no questions, I guess we can just wrap it up here. Like it says on the screen, we can be reached at 240-391-6370 for free legal advice and also representation. And we can be reached by email at info@clspgc.org.
All right, thanks everyone. Take care.